Hello, my name is Michael Busby. I am a Texas family law and divorce attorney. In this video presentation, I will go over civil wiretap claims, those claims having been made in a family law matter for which you can bring a cause of action. In family law, it is not uncommon for a party to survey, wiretap, audio tape, videotape the party's spouse and the spouse's significant other or the children. Family law clients will sometimes intercept emails, text messages, phone calls, or other electronic communications, thinking they are doing so will help their case. This area of the law is really wrought with peril, both civilly and criminally. You have a Federal Wiretapping Act, which has been applied in family law cases, Federal Stored Communications Act, and other related statutes that are complex. And as they are complex, they give you they give you liability in both a cause of action for the person you've surveyed. And in Texas, there's a civil cause of action exists for the wrongful interception of communication that is codified in Chapter 123 of the Texas Civil Practices and Remedies Code, entitled Interception of Communication. The statute provides for injunctive relief in a civil claim for $10,000 in damages per violation of the statute, as well as attorney's fees. I will read at you the statute, which provides as follows. There's a definition in this chapter. Communication means speech uttered by a person or information, including speech that is transmitted in whole, in part, with the aid of a wire or a cable. Interception means the oral acquisition of the contents of a communication through the use and interception of a device that is made without the consent of the party to the communication, but does not include the ordinary use of a telephone or telegraph instrument or faculty or telephone and telegraph equipment, a hearing aid designed to correct subnormal hearing to not better than normal, a radio, television, or other wireless receiver, or cable system that relays a public wireless broadcast from a common antenna to a receiver. Under the Texas Civil Practice and Remedies Code, Section 123.001, a cause of action, a party to a communication may sue a person who intercepts, attempts to intercept, or employs or obtains another to attempt to intercept the communication, uses or divulges information that he knows or reasonably should know was obtained by interception of the communication, or as a landlord, building operator, or communication common carrier, either personally or through an agent or employee, aids or knowingly permits interception or attempted interception of the communication. This section does not apply to a party to a communication if the interception or attempted interception of the communication is authorized by Title 18 of the United States Code, Section 2516. Under the Texas Civil Practice and Remedies Code, Section 123.002, your damages, a person who establishes a cause of action under this subchapter is entitled to an injunction prohibiting a further interception, attempted interception, or divergence or use of information obtained by an interception, statutory damages of $10,000 per each occurrence, all actual damages in excess of $10,000, punitive damages in amount to be determined by the court or a jury, reasonable attorney's fees and cost. So what you have is a situation where one spouse may think that the other spouse is cheating, so they want to set up a surveillance system that they allege is for security in the house, and they don't tell the other spouse that they're doing this, and the excuse is, well, it was for security. So when you secure bedrooms and bathrooms, generally you will not get very far with this argument. If you do common areas, hallways, and then entryways into the home, you sometimes can get excused. But again, it's really you're going down a slippery slope if you install this type of security system without informing your spouse. And then you have applications on phones that is meant to pick up phone calls that your spouse may be having with lovers. And so that's also something that, it will get you in hot water pretty fast. So I would say that before you publish this or you attempt to use it offensively in a trial proceeding, discuss it with an attorney as to how did you come about this. So I've had women who have taken pictures of themselves with a penis in their mouth and sent it to their husband saying, this is what I'm doing with my new boyfriend. And so that is a party admission. And as that is a party admission, that husband was allowed to use that because it was not, he did not intercept that. She admitted to it, and she was bragging and tormenting him as to her new relationship. So the facts as may play out in your obtaining certain communications or certain admissions, you want to save them and don't use them until you talk to an attorney about how possibly it could be used or should you destroy it. My name is Michael Busby. I am a Houston, Texas family law and divorce attorney. Thank you for watching.